what if you trip over your own feet? Would that be a workers' comp claim? So this fact pattern came up in an April 29th, 2025 full commission hearing decision. And what ended up happening is this lady was in her job's cafeteria, so her wherever she worked had a cafeteria. She turned around, walked a few steps, and ended up falling. And she ended up breaking her arm. And the full commission basically came to the conclusion that there was nothing wrong with the floor. There was no carpet. It wasn't slick, and it wasn't an unexplained slip and fall. If it was unexplained and she had eliminated idiopathic reasons, i.e. she didn't have a seizure, she didn't pass out or whatever, then if it's an unexplained slip fall, then it might be a compensable claim. But in this case, she said, she explained, oh, my foot got caught on the floor, my shoe got caught on the floor, and then so it wasn't unexplained of how she felt. That's what she testified to. And so because of that, they applied this Lord versus Darty test, totality of the circumstances test, and that considers remember, I've talked about this before with the zone of employment. It's an exception in that situation too, but it's the proximity of the workplace to where the injury occurred, the control of where the injury occurred by the employer, and the benefit to the employer for the injured worker being in that location where they got injured. They applied those three things, and they found that under that analysis, it's not a compensable claim, which I don't really quite understand that, because the benefit to the employer, it benefits the employer to have your injured workers eat lunch on the facility, and but they didn't put a lot of weight in that. And the proximity, it's in the workplace, it's in their cafeteria, and the control, they kind of took a weird analysis of that. It's a control of where the injury occurred is the way I look at it. They said they applied it as the control of the circumstances. And I'm not sure if that's correct. I don't think it is. But they said, hey, they didn't have control of the situation. They didn't have control of her feet, something like this. And so they said, under the Lord v. Darty, totality of the circumstances test, not a compensable claim. And what they cited in this full commission order was this Daly versus AutoZone case, and that's different from the AutoZone case that happened last year. But basically it says just because an injury occurred on the employer's premises doesn't mean that it's always a workers' comp claim. The Workers' Compensation Act is not meant to impose a duty on an employer to be an absolute insurer of employee safety. So in that case, they said not a compensable claim. You're on your own, paying your bills and getting compensation for the time off.